Try for the appellant, my lord.
Yes.
Filing my affidavit of service. My lord, so far as the respondent number 2 is concerned, my lord, it couldn't be served. It has been sent, the door was locked, and others have been duly served.
Mr. Banerjee, you are appealing for whom?
R1, respondent number 1.
My lord,
We need a short affidavit on this. There is already an injunction till the disposal of the application. A short affidavit may be needed. We'll come back.
I will file my reply, my lord.
This is from eviction degree.
No, my lord, this is a suit for declaration.
Suit for declaration.
Dismissed or granted?
It was dismissed, my lord, holding everything in favor of me, that I have a right of tenancy, but saying that I cannot compel the landlord for repairing. I am covered by several judgments, my lord. I will be relying upon those.
And I am the act of God person who says that this is not my act, it's an act of God, and therefore your tenancy is extinguished. So that's the point in issue.
But that issue has already been decided in my.
How long will God take to use the affidavit?
God might take, God will take a microsecond, I will take 2 weeks.
2 weeks.
Or what?
Blessings of God.
That is 1 week.
What are you doing, Mr.
1 week.
On the prayer of learned senior advocate appearing for the respondent number 1, the respondents are directed to file affidavit in opposition to the application within a week from date. Full stop reply if any shall be filed within how much time?
1 week, my lord.
Within a week thereafter, full stop. The matter shall next be listed. The application shall next be listed for hearing under the same heading on May 7, 2025.
Great.
Affidavit of service filed today be kept on.
Great.
Memo. The memo.
দিয়ে দো আজকে এখন নেই আমার কাছে দাদা আমি তো আমার কথা হিসেবে মেমো নেই অ্যাসিওর আমি তো বিজেপি দিয়েছি
Your Lordship, I am for the plaintiffs, Your Lordship, respondent number 1 and 2.
This is my appeal. I am the one of the defendants in the suit. Suit filed by the plaintiff seeking partition of 2 flats. The flats are joint and contiguous, were all along used by all the parties to the suit as common residence. Plaintiff is my brother. The other defendants are my sons. Now, one of them is my son. Both are my sons. Now,
you have come up against a preliminary decree?
Yes, the preliminary decree by which shares have been determined only in respect of one of the flats, not the other.
Subject matter was both?
Was both. And the relief sought in the plaint is for partition of the entire suit property. Learned court, formulates.
If you agree, we can remand it for the.
In fact, I filed my written statement saying I have no objection to partition of both the flats together. Learned trial court also formulates the question whether they can be partitioned piecemeal or whether both will have to be taken into the hotspot. Noticing that all the parties are there to the suit,
why didn't the court
ultimately finds that they have to be taken in the hotspot and partitioned together, but ultimately only declares the share.
Both of you agree, then we can remand it.
I have got my share, Your Lordship. I am the plaintiff. Lordship, kindly take 112.
I am the main defendant in this.
Lordship, 102.
So what is your objection? That the other flat is also.
The first is that there are 4 parties to the suit. The 2 flats.
You are the sons, his son?
No, the brothers. No, I am the son.
I am the uncle.
He's the uncle. He's my brother. Now, 2 flats.
You are appealing for 2 of the defendants?
I'm appealing for 2 of the defendants. There's another appeal which is not in list today, which is the appeal number 173.
That is your appeal?
That is my appeal.
Your appeal is on the same ground?
On the same ground, same order. Finally, Your Lordship, the suit has been disposed of at the time of Your Lordship.
So you are the thorn in the way of these parties having a.
They are in the same boat. I'm in a different boat.
No, but what is your objection?
Objection is the 2 flats are different, distinct, purchased by separate deeds, corporation tax separately paid, electricity bills separately paid. In a multi-storied building, the flats are, the maintenance bills are separate. Everything is separate. These are first round of defense. Second is the plaintiff is the co-owner of flat number 3A, who has sought for partition. The plaintiff is not a owner.
No, but admittedly, all of these were owned by your predecessor in interest.
No. It was purchased separate. It was not a single.
Purchased by whom? The other
Purch-
flat, the
yes,
one in
It is
plaintiff purchased the one in which it has been granted.
plaintiff purchased the one
And who
along with one of my client.
All right. And
50-50.
who purchased the other one?
Other one is
But
my uncle
along with one of
along
Mithra's
my,
client.
my client. So I am there in both the flats. 50-50. The deed says that.
But can these properties be joined then in the same property, in the same?
That's the finding of the court.
Well,
Can't be.
That is the finding of the court. Kindly, well, first kindly takes.
Because they are not co-owner in the other flat and you are not co-owner in the
Yes.
in their
So
flat.
That
kind-
issue, your lordship,
Has
has
the misjoinder of the property subject matter.
Well, that issue had earlier arisen. Well, they had filed an application under Order 1 Rule 10, from which we came up in 227. Court found well, that they have to be well, in the same suit.
But that
Learned-
has to be interlocutory finding.
Well, learned court
Yes.
also arrives at that conclusion that they have to be well, partitioned together. Well, it kindly has a look. Well, it first takes the plaint. I'll just show your lordship the prayer in the plaint and the schedule.
147. I
Well,
think.
plaint starts at
106.
106.
You go and file a different partition suit regarding the other property, and we can direct that property to be expunged from this suit then.
Lordship,
Otherwise, they won't be able to
may I
do it
indicate your
from
lordship?
your suit.
Lordship, kindly take page 147. This issue arose and your lordship
Well,
has been
since
decided.
he's already placing, your learned friend is already placing one friend.
Kindly
let us
takes
hear him then.
page 112.
We just wanted to get a
106.
contour of the matter. Take your seats there. Let him argue. Then we'll hear it. Yes.
Well, at 106, the plaint starts.
106, right?
Lordship will see. Well, I am defendant number 3, Ramesh.
All right.
Well, it kindly comes to page 111.
There is no Suresh in this. Only Mahesh.
Only Ramesh.
Only Ramesh.
Well, 111 is the prayers. Preliminary decree, well, prayer B, preliminary decree of the partition suit, preliminary decree for partition of the suit property and the additional suit property.
But the
Now
schedule
kindly
is
see the schedule at page 112.
That is the important.
Yes, 112.
Right.
Flat number 3A, measuring an area of 2,100 square feet, comprising of 2 bedrooms, attached bath, privy, 1 Thakur God, 1 common kitchen, so on.
And
And well, it kindly sees 5th line, flat number 3B, measuring an area of 2,100 square feet, comprising of such and such.
But how can they be joined together?
Now, Millet kindly sees, Millet,
He is not the owner of 3A.
Well,
Is joined by whom?
Mr. Chaudhary is leading me.
Mr. Chaudhary is also owner of one of.
Well, he's leading me.
3A is owned by whom, Mr. Chaudhary? You and.
3A is
Mr.
owned
Vikram.
by plaintiff and defendant number 2. 3B was owned by defendant numbers 1 and 3. One's share has gone to 4 by gift. Suit is in respect of both flats together. Both flats, my lord, the developer was requested to
But the
remove.
co-owners are not the same in respect of both the flats. Because regarding
Yes.
one co-owner may be same,
Yes.
but suppose X is not the co-owner in 3B, and Y is not the co-owner in 3A.
Yes.
Now, how can you obtain a partition by
It's not
keeping it
2
in the-
flats. It's 1 flat. It's numbered in the building as A and B. If my lord, we could have bought it
The
as A
state
and B.
deeds are different.
6 deeds. 6 deeds of a large flat without a wall in the middle. Finding of the learned court is that this is one property. And then the learned court, my lord, makes, my lord, this error. I humbly submit. My lord, may I just show your lordship the findings? It's one property. My lord, I can today have I can buy a large flat, which, my lord, could have been, say, 2 or 3 flats.
But just because there is no boundary wall or wall in
Yes.
between, that does not make it a common property because you have purchased by separate deeds, demarcated flats. These are different flats. There is no wall. That does not mean that it is not demarcated. It's demarcated by boundary in your deeds. 2 flats, independent flats, purchased separately. So just because there is no boundary, I mean,
No, we were able to prove by evidence that this is essentially one property.
but the sale deeds go on to show the ownership.
Yes,
The sale deed, one sale deed carries, I mean, has you and someone else as the owner. The other sale deed regarding a demarcated flat is between 2 other persons. One may be common. So how can you join the 2?
Milord,
Just because there is no wall physically.
Milord, if it is, Milord, the position that one larger property is purchased by 2 deeds, Milord, I wouldn't
But
have to fi-
demarcated. 2 deeds not, no, then the co-owners have to be same, Mr. Chaudhary. You are right. Can be several deeds,
Yes,
but the co-owners have to be co-owners in all the properties.
correct.
in all the deeds. If the co-owners are not common in all the deeds, they cannot file a suit together because there are judgments also on such count. Both sides must be having judgments. But if two separate flats are purchased, demarcated flats, flat numbers are there, demarcation must be there in this schedule
But
itself.
if I did not file one suit,
You cannot have a partition in 3B because you are not a co-owner of 3B at all.
I'll be given half of 3A.
3A, you can file a separate suit and get with your co-owner in 3A and get a partition between yourselves. But 3B is not your property at all.
So then
Because
3A.
you have not purchased 3B. You are not an owner of 3B.
Now, my lord, may I show your lordship the finding, my lord, once? And then, my lord, I'll go by a practical solution to this. If your lordship feels that no, then you put up a wall between 3A and 3B. That I'm entitled to.
No. Is there, have you got the sale deeds here? Annexed
Yes,
here?
yes. My lord,
What
please.
was the schedules of any one of the sale deeds?
Yes.
Either 3 or
But
3.
may I just hand up, my lord? We've also prepared paper books for expeditious disposal. Or also on the stay petition. 220. I've served the paper books also. The serve colony, na? Now, here it's with us. We'll give it right now if required.
Paper books for stay petition
No,
for the appeal.
for the appeal. So that will not, because their victory is an adjournment. I filed a criminal contempt because of the
First
delay.
one of the sale
Yes.
deeds. The schedules of any of the sale deeds.
Please, my lord, have a
Sale
look.
deeds.
First, my lord, is at, my lord, page 1, very well. One of them is at 229. So if your lordships take 229.
Where is the schedule? 229 is the schedule.
No, it starts from below
229.
229.
Oh,
And I
220.
just come to the schedule.